Emily Ager had endured nearly 2 years of anticipation, waiting for the trial of the man she had accused of R-wording her. Fearing the prospect of testifying against Julio Salguero Quinteros, she had requested the presence of a support dog, a request that was granted by Justice Brock Jones in the summer. She courageously took the stand, determined to seek justice. Tragically, that chance for justice would be forever lost. On November 7, 2023, prosecutors were forced to stay the criminal charge against Quinteros due to a breach of his right to a timely trial. Justice Jones, along with his fellow judges, harshly criticized the breakdown of justice at the new billion-dollar Armory Street building in Toronto, which had already seen numerous cases dismissed due to delays since its opening 7 months earlier. Jones remarked, "This case is yet another illustration of how persistent court closures in the new Toronto courthouse inevitably led to extended delays. It is yet another example of the government's failure to ensure the courthouse could operate at full capacity each day, resulting in tragic consequences." Quinteros had been arrested on February 12, 2022, with his 3-day trial scheduled to commence on July 5, 2023. However, due to court closures, there were no courtrooms available on that day, leading to adjournments to July 6th and then to July 7th, when the trial finally began. During her testimony, Ager alleged that she had invited Quinteros to her apartment and after falling asleep, woke up to find him engaging in non-consensual intercourse with her. After her testimony and cross-examination, the Crown concluded its case. The defense intended to call the accused to testify, but there was no time left in the day. The next available trial dates were 4 months later, but the trial did not resume in November as scheduled. Quinteros' lawyer had filed something called an 11B application, referring to paragraph B of section 11 of the Charter of Rights and Freedoms, which states that any person charged with an offense has the right to be tried within a reasonable time. I'm going to take a quick sidebar here to explain this constitutional entitlement so we can understand how things went so wrong in this criminal case. You might be wondering if the words "within a reasonable time" involves an actual deadline. Up until 2016, it didn't. However, the Supreme Court of Canada, in the case of R versus Jordan, introduced a new framework that was more rigid and clear-cut. It set a ceiling on the amount of time that can elapse from the date someone is charged with a crime to the actual or anticipated end of a trial. That deadline is 18 months for cases in provincial courts and 30 months for cases in superior courts. Depending on the type of offense, a case against a person will proceed in one of these two courts. If the actual time exceeds these limits, the delay is presumed to be unreasonable, and the burden shifts to the Crown to prove that there are exceptional circumstances, which could include particularly complex cases or delays caused by the defense lawyer. The Supreme Court's decision aimed to prompt a cultural shift towards a more expedient justice system, emphasizing the importance of timely trials as a part of the right to a fair trial. Unfortunately, this has not been the result of the Supreme Court's decision. Rather than prompting a nationwide cultural shift in the justice system towards more expedient justice, cases that have failed to meet this deadline have been thrown out across the country, including the most serious violent crimes, which I'm sure you know what I'm referring to. Getting back to the case against Mr. Quinteros, Justice Jones expressed his frustration, stating, "There is no reason this case could not have been completed within the 18-month Jordan timeline had the courts been adequately staffed in July. Instead, 2 full days of court time were lost." He went on to say, "Mr. Salguero Quinteros' trial should have been decided on its merits. Both he and the complainant deserve to have a court determine if the Crown could prove its case. That will now never happen. This alone is regrettable. However, the reason for this outcome is disgraceful and tarnishes the administration of justice." Justice Peter Fraser had similarly voiced his concerns in September when he had to dismiss a sexual assault charge against a minor due to the closure of 343 courtrooms at 10 Armory Street between March 31st and July 6th. Justice David Porter had made similar remarks in August when he stayed an impaired driving charge due to persistent staff shortages. The Attorney General's spokesman, Andrew Kennedy, stated that the ministry is actively recruiting more full-time staff, emphasizing that any courtroom closure is unacceptable and efforts are underway to ensure sufficient court staff are available for the delivery of justice. Unfortunately, these efforts come too late for a woman who had bravely come forward. As Justice Jones concluded, this case should serve as a chilling reminder that this inexcusable state of affairs must never be allowed to happen again. When charges are stayed due to delays, real people's lives are impacted, and the emotional trauma associated with never knowing the outcome of a case on its merits can be long-lasting and severe for both victims and accused individuals. The question is, how did we get here? And why is this happening? In August 2016, the Chief Justice of the Supreme Court of Canada at that time, Beverly McLaughlin, described the substantial number of unfilled federal judicial positions as a crisis. However, she emphasized that this was not just any crisis, but a perpetual crisis, a continuous and unending one. This description might have seemed exaggerated then, but over 8 years later, the situation remains unresolved. As of the start of this year, there were 78 vacancies in federal judgeships, accounting for nearly 8% of judges nationwide. In Ontario, the vacancy rate is even higher, approaching 10%. The consequences of these vacancies became starkly evident in Toronto in December, when Justice Maureen Forstell had to stay sexual assault charges in another criminal case due to trial delays. Forstell pointed out that these delays could have been avoided if the judicial positions in Toronto were filled. She referenced remarks from Beverly McLaughlin's successor, current Supreme Court Chief Justice Richard Wagner, who had previously written to Prime Minister Justin Trudeau, urging faster judicial appointments and expressing frustration over the lack of explanations for the delays. The underlying reasons for these delays remain unclear, making it difficult to come up with solutions. At first glance, filling these vacancies might seem straightforward. The government could simply plan for more judges as older judges retire. However, as Forstell noted in her decision, this expectation has not been met. There are unique challenges in appointing judges given their role in assessing the constitutionality of government actions. To ensure appointments are based on merit and not politics, candidates are vetted by independent judicial advisory committees. There are 17 such committees across Canada, including 3 in Ontario. However, their operations have often been suspended due to the government's failure to appoint committee members. In September, the current Justice Minister, Arif Virani, announced changes to extend the terms and assessment validity periods for JAC members, which should reduce the frequency of committee inactivity. Nonetheless, as long as the government is slow in appointing new members, judicial vacancies will continue to exist. Addressing this issue is crucial, and it requires the federal government to consistently staff these committees. However, Justice Minister Virani and others have identified another challenge: attracting diverse candidates to the federal bench. As a lawyer who has worked in our justice system for almost a decade now, I must disagree with Mr. Virani's claim that a lack of diversity is somehow responsible for the shortage of judges. To me, it sounds like nothing more than a bad excuse. There are thousands of highly experienced, highly qualified lawyers from all walks of life in this country who would all make excellent judges, provided that the government took the necessary steps to actually recruit them. Moreover, by claiming that the quest for diversity and inclusion must take priority over solving the crisis in our justice system, which is essentially what Mr. Virani is saying, it makes it seem like citizens and residents who try to hold the government accountable for the government's failures are automatically against diversity, which we all know just isn't true. If there's one thing you take away from this video, it would be that when the next election comes along in Canada, and it comes time to choose our next Prime Minister, consider voting for the leader that you think is most likely to successfully solve the crisis in our justice system so that victims can see their abusers punished and people who do terrible things in this country are held accountable for their actions. Feel free to let me know your thoughts in the comments. If you found this content interesting, then don't forget to hit that like and follow button. I'm Ryan Keeney, and thanks for watching.